that's working. G'day, Brett. And I'll introduce Brett, who's going to talk today about estate challenges and having a look at protecting an estate from both a challenge under the normal provisions and then also having a look at superannuation and some issues that come with that in terms of challenging superannuation decisions. So for those that haven't met him before, Brett's one of the other principals of the firm here at Cleary Hoare. He's the managing principal and has been for quite some time. He concentrates, or he likes to work, I should say, in regional and rural areas and up in the northwest of Australia and in the mining communities and with Indigenous groups. So it's very rare to find him in the office, but we've managed to drag him into the office today. I think all of the border closures have helped with respect to that. And he'll be presenting today. I think you'll find it's a good presentation, and he's a very experienced at video webinars. This is his second video webinar. He did his first one this morning. So without further ado, I'll turn off and I'll hand over to Brett to start the presentation.
Thanks, Adrian. Good morning to everyone who's in the West and good afternoon to everyone in the East. I'll just get our screen up and running. The title of the workshop or the webinar today is Estate Planning Challenges, and by that we mean, what can you do to address the prospective challenge as opposed to how challenging is the estate planning process, which is probably a different topic altogether. And in that context, we thought we'd position the paper based on a case study and drew that case study from a Victorian family who managed to get themselves into two separate fights in the Supreme Court in their estate, which extended from a relatively straightforward challenge to a will right into a Supreme Court challenge to fiduciary duties of trustees of superannuation funds. So we won't be boring you with a lot of detail there, but we will look at the main points of that case and put it in a case study format. So our case study is about Rick and Helen. They had been married for 29 years. They didn't have any children together. Helen had children from an earlier relationship, Charles and Caroline, and her daughter Caroline is married to Martin. Predictably, there is some tension, or was some tension between Rick and his stepdaughter Caroline, and it's safe to say that tension probably was fundamental to why there was a challenge and why the fights went the way they went. In addition to the assets in Helen's name, she also had a self-managed superannuation fund of which she was the only member, but she had appointed her daughter Caroline together with her as a trustee. So against that background, Helen dies. And the issues that emerge fairly quickly, and there's a time limit to this, you've got the date of death plus 6 months if you're a beneficiary of an estate to work out whether you're happy with what you think you're going to receive under the estate. Within that 6-month period, her widower, Rick, decided he didn't get what he had expected under the estate, and so he made a claim that he should have got more from her estate, and further than that, that the ongoing trustees of the super fund didn't do the right thing, breached their fiduciary duties, and all that should be unwound as well. So on the face of it, it looks like Rick was the protagonist here, and he's certainly the one who brought both claims. Looking at the estate pool for Helen, in her own name, she had a house at $1.5 million in value, had a home unit at $550 with some liabilities, probably mostly bank debt relating to one or both of the properties. And in addition to that, she had some superannuation fund monies as the sole member at about $450,000, which we'll come to later. So we're going to sort of split the presentation into two phases, one being what happened in the estate challenge and how might that be addressed to make sure that if your clients are in a similar position, they don't suffer the same fate. And the second aspect of this presentation, we look at what was the dispute about in the self-managed superannuation fund. Overall, Helen's intentions were fairly simple, and I'm sure you've all got clients that have similar intentions with their estates. She wanted her husband of 29 years, Rick, to be able to live in a comfortable home, and so in her will, she said, "I give Rick a life interest in the unit, not the family home, in the unit. That was the one that was market valued at about $550,000. She allows him to stay in it for life, puts an obligation on the executors of the estate to pay any mortgage payments on that asset, upgrades, maintenance, utilities, and so on, and further asks the executors to invest $100,000 in the estate to cover those sort of expenses on the unit. And then the balance of the estate, whatever that's comprised of, which on our understanding was the family home at 1.5, and probably some cash at bank and stuff like that. That was to go to the children equally, Charles and Caroline. Now, don't worry, I'm not going to go through this table with you in any great detail. The purpose of it is to point out that estate challenges and estate planning and estate administration is not a federal legislative sphere. It's state-based, and so in each state there's separate pieces of legislation dealing with the two main aspects of estate planning. That is, firstly, estate planning is what do you do and what are your obligations and how do you create a valid will. And in Queensland, it's under the Succession Act, New South Wales similar, and then the Wills Acts in each of the other states and territories. But also has rules for how you properly sign a will and so on. Then there's a separate bundle of legislation in each state that which deals with what we might call estate administration, and that is what happens after someone dies, what are the obligations on executors and trustees, what are the rights of other people to make challenges to wills, what happens if you don't have a will, and so on. And that bundle of legislation in each state's the Succession Act in each of Queensland and New South Wales, and then probate acts and so on in the other states and territories. For the purposes of the individual estate of Helen, when she died, her estate, as all estates are, is confined to assets in her own name. So assets that are registered in her name, property, real estate, either as sole owner or as tenant in common. And that doesn't include property owned as joint tenants, which we'll come to later. Shares in companies, even shares in trustee companies, private companies, units in unit trusts, listed or unlisted, cash at bank and other valuables, art, collectibles, vehicles and so on. So other valuables would include any form of personal property. And all of those assets, when we looked at the short version of that for Helen, came to this asset pool, house at 1.5, unit at 550 with some liabilities. And having said all of that, there's a carve out and there's some exceptions. And the main exception is in New South Wales. And when we say New South Wales, it doesn't mean, oh, my clients, I don't have any clients in New South Wales that won't apply to me. There are provisions in the New South Wales legislation which deals specifically with assets located in New South Wales and whether those assets are in the list of the estate of the deceased or not. And the provisions in New South Wales introduce a concept called notional estate. And those of you who have had experience in bankruptcy world, Corporations Act and insolvency, and are broadly familiar with concepts like clawback and relation back periods and so on, this is a similar concept. So even though at the date of death, that precise moment, the estate of Helen is made up of those individual assets, it would be possible if she was in New South Wales to include other assets. In fact, those assets are defined terms and defined in the legislation as relevant property and relevant property which may have been affected by a transaction within the prescribed time. So let's have a quick look at that before we get back to the main show. So if there is a transaction which occurs 3 years prior to someone's death in New South Wales, or New South Wales property, 3 years prior to someone's death, and if that transaction happened with the intention of denying or limiting provision of someone in the estate, or if that transaction happened a year prior to the death of the testator where the deceased had a moral obligation to provide for a person, or if transactions happen on or after the deceased's death. So we're really looking at what are transactions which have occurred and which could be undone by someone who made an application of the New South Wales Supreme Court for those transactions to be attacked. When you get into the nitty-gritty of the legislation, which we won't do today, you would have thought transactions are something that would be confined to transfers of assets and so on. In fact, it can even include things which haven't happened but which ought to have happened. For example, there's been a case in New South Wales where assets in a discretionary trust where the deceased was the sole trustee, those assets were brought into the estate because the court made a finding that the deceased failed to distribute the assets to himself prior to death so that they'd be part of the deceased estate. That's extraordinary. I'm not sure that it's going to be followed in a hurry, but it is a very controversial example of the use of the notional estate provisions in New South Wales. By and large, though, when we've been involved in those sort of disputes, it's been about transfer of assets in a period of time within 3 years prior to the death of the testator. Other than New South Wales, then estate assets do not include assets owned by discretionary trusts, unit trusts and so on. They don't include assets owned in companies. They don't include assets owned in superannuation funds unless those funds are directed into the estate by death benefit nomination or a decision of a trustee. It doesn't include assets owned as joint tenants, and in capital cities in Australia we've seen a number of examples of very unhappy families where mum and dad are divorced, one of them remarries, they take the original family home, but it's transferred as joint tenants to the parent plus a step parent. The parent dies and the step parent inherits what is sometimes a very valuable property in a capital city, and it doesn't touch the estate at all. So that can be a downside of joint tenants. On the other hand, depending on whose side you're on, it can be an advantage. Just be aware that assets owned as joint tenants pass to the surviving joint tenants on death of one of them, and it doesn't fall into the estate of the deceased. And again, caution the notional estate rules in New South Wales. So that's a bit of technical background. When we say we've got a challenge in our state, what does that mean? For the purposes of this presentation, it means that someone is unhappy with what they've received under a will, as opposed to saying, well, the deceased was crazy when they signed the will, or the will is invalid. So we're not challenging the existence of or validity of the will generally. This sort of application is about making further provision for someone under the estate. And what we're really doing, if someone makes this application, is they're applying to the court, the Supreme Court in each state, to have the will rewritten to some extent in their favour. So as we looked at in that table earlier, there's different provision in each state. Each state, broadly, it runs parallel other than the notional estate provisions in New South Wales, and it's designed to protect disaffected eligible persons where the deceased had a moral obligation to provide for them but didn't do so. Who's an eligible person? In every state, it includes the spouse of the deceased, a de facto partner, a child or a dependent person. In New South Wales, it also includes a former spouse, and the same in Victoria and WA, and goes even further in Victoria to include a member of a household, and former spouse, a spouse of a child, and so on. So fairly broad a bundle of people who, if they're unhappy with provision for them under a will, they can seek to have more provision made for them by the Supreme Court. Sort of things the court would consider in entertaining that application is whether the applicant is within time to make the application, and the time limit's quite strict. So in each state, you have the date of death plus 6 months. Very strictly, that's the time period where if anyone wants to make a claim, they've got to make or at least give notice of the claim to the executors in that time frame. If they do that, then they've got some other hurdles to jump over, but they can have another 3 months within which to actually file proceedings. There are some provisions which allow the applicant to ask for leave of the court to make an application late, but that's unusual and generally quite a big gully to jump over. So if they're at the starting line, they're proximate enough, so they're close enough to the deceased by relationship or by dependency to be eligible to make an application. They're within time, they file the proceedings, and they get to the point where a judge is looking at the sort of things that he or she would take into account in deciding the application. They go beyond those things and look at what are the obligations or responsibilities of the deceased to look after this applicant. How big is the estate? Is it made up of divisible things, or is it something in the nature of a cattle station or large things that are difficult to divide up? What are the financial resources of the applicant, the eligible person? Do they really need the money, or is this driven by something else? Does the applicant have any disabilities that need to be taken into account? How old are they? Did they make contribution to the estate? By that, we generally take it to mean that, for another farming example, it's not uncommon for a farming child to accept low wages and generally pretty meagre conditions for a long period of time on the promise that their parents would make a gift of the farm to them in their will. And that's, by contribution, we mean they've really foregone something for the benefit of the deceased during the deceased's lifetime.
Sorry to interrupt, Brett. Just a question from Brad. He's asked two different classes of people and whether they're eligible to claim daughters-in-laws or in-laws and grandchildren.
Well, they're eligible to claim if they can show that they were dependent on the deceased, so they made a contribution and so on. But if you just go back to that earlier slide here, if they don't fall within those definitions in the relevant state, then their only way of getting in is by demonstrating that they are dependent or were dependent on the deceased prior to death, or they made a contribution, or those sorts of claims. That's a much more difficult claim to progress, but that would be the basis on which they would make that application.
Thanks, Brett. And Brad says thanks as well.
No problem. So yeah, some other factors to consider. Was the applicant maintained by the deceased? Was the deceased looking after them, and they had an expectation that they would continue to be looked after? It might be relevant to Brad's question as well. They may have even gone further. There may be a liability and obligation to maintain the applicant, and at some level, the court, as we're all human beings, will look at the character and conduct of the applicant in the course of the proceedings to, as much as possible, to see that the applicant comes to the court with clean hands and is not, misleading anyone. Finally, they also look at the effect of this order on the other beneficiaries, and this factor is pretty interesting because there's a couple of things that drive it. One is that most lawyers will work out fairly quickly that if they act for an applicant in a family provision application, they're a fair chance of having their costs paid out of the estate. Not guaranteed, but it's a fairly good chance. So you'll find there's quite a few lawyers around who'll punt this sort of action. And then what that does then is, when you look at this factor, is all the other beneficiaries see a particular person making an application, and they will realise, when you look at these factors, that if they don't make an application as well, they're not at the table. They're not at the table in the negotiations, and they may not be at the table in the court proceedings if it gets that far. So it has the effect of, in some cases, it's sort of one in, all in type approach. If one person makes a claim, then everyone else may as well, to make sure that they're on a level playing field as much as possible. And the only person, or the only people who win in that scenario, of course, are lawyers. So looking at, well, the fight starts, and what would you think is the court's role in all of this? Remembering we have an adversarial system of justice, the court isn't there to work out who's right or wrong. It's just there to listen to the people in front of it, listen to those people argue with each other in an adversarial way, call evidence, challenge evidence, and determine on that day or in that trial who has the most compelling argument. And so its function then, and this is taken from the Marcella case, which is what we've been talking about so far today, court's function is not to ensure a fair distribution of the testator's estate or to achieve equality among claimants, but goes no further than just making adequate provision for the proper maintenance support of an applicant. So who's in front of me, and what are the merits of their claim? So in that context, and in the context of the family structure that we have, with Rick and Helen being married 29 years, Helen having children from a previous relationship and so on, it's a bit of a red flag to any lawyer, and probably even advisors like accountants and financial advisors, to be alert to the prospect of a challenge in these circumstances. It's possible someone will be unhappy with whatever the plan that Helen comes up with. So she must have had some inkling of it, and she put a provision in her will along the lines that by agreement, not sure with who, but by agreement, and bearing in mind that the assets disposed of in this will were premarital assets acquired during her previous marriage, and that Rick has money of his own and other business interests, she chose to make the provision that she did. So limiting Rick's rights to a life interest in the unit, and the balance of the estate pretty much going to the children eventually.
Hi, Brett. To interrupt, a question from Mike. Who is contacted if there is an estate challenge?
Sorry, I just missed that last few words.
Yep. Who is contacted if there is an estate challenge?
Okay, so the duties are that if the executors receive notice of a challenge, so that usually means a letter or an email, putting them on notice that so-and-so acts for a particular person and we want to make a claim under the family provision legislation. There's no duty on the executor to tell all the other beneficiaries about the claim before doing anything else, although ultimately the executors do have an obligation to account and to inform the beneficiaries of the net value of the estate, and part of that would be, well, the net value is made up of assets A, B and C and liabilities of D, but we can't make a distribution because we need to deal with a claim by Mrs. whoever. So there's no, the only communication is between the claimant and the executors initially. Ultimately, it will go wider, but there's no formal requirement to let anyone else know about it. So the outcome of the court's decision, it's going back one more, having this provision in the will, something you'd probably call the sort of window dressing, really. In other words, the question we're often asked is, does this work? Putting in things like this or paragraphs like I've already provided for Adrian Bailey, I don't need to give him anything more. Will that stop him or anyone else having a go at the will? The answer is, well, it kind of does work, but it doesn't stop it. So that wording in wills or in other documents will be part of the argument about whether a particular claimant should be successful or not, but it doesn't stop the fight. And as you'll see, the outcome in Helen's will was that Rick was fairly successful. He had a much better outcome in terms of his life interest because he had a life interest in the house, not in a unit. He was allowed to downsize to something else, to supported living or a smaller house, whatever. If there was a surplus from the sale of the house, then he was going to get a small income from the earnings of the investment of those proceeds for life. You got 100 large up front, $100,000 junior gift, and only after all of that did the assets pass to the children, Charles and Caroline. I suspect the children would have been fairly unhappy about that, but that was the outcome. What would be different if a different approach was taken to this? And by different approach, we don't mean, with different wording in the will, or had there been some statement or statutory declaration that Rick shouldn't get any more than this for whatever reason. The will and what is in the four corners of the will document is Helen's only real mouthpiece from the grave. That said, there were significant elements of the dispute relating to what her real intentions were, but none of that really made it to a position where her wishes were binding, no matter who was unhappy. And that's what we'll probably move to now, is what sort of planning could be done to make this enforceable, even if beneficiaries are unhappy with the outcome. Before we do that, we'll just digress for one slide to a case, a South Australian case called Barnes and Barnes, because where we're headed to in our solution for this, or our preferred approach to the planning of the transaction, the transaction being movement of assets on Helen's death, where we're going with that is to look at another concept, that is, well, what comprises the estate. We know it's the assets in the individual's name. We know that if there are liabilities of the estate, they've got to be dealt with first. particularly, say, bank liabilities and other creditors. So we're really saying you can have all the challenges you like, but you only get to challenge what's left on the table after real liabilities are met. So we had a case in Barnes and Barnes, and up to 2003, the law was that if you had a deal between the family that the will would be done in a certain way, then that deal was in effect a contract, often a deed, but had the effect of imposing an obligation on the estate to fulfil that contract before any other provision was dealt with. Barnes and Barnes was a farming case, mum and dad and son farming away. Son relied on mum and dad to make a gift of the assets to him as part of the deal, where he forewent wages and other sorts of privileges and entitlements over a long period of time to fulfil that deal. So the contract between the three of them was that mum and dad would leave a will in a certain form to make those gifts. Unfortunately, that's as far as the contract went. And the argument in the High Court was, well, yes, the obligation to perform a contract is a liability on the estate, but in this case, the contract was actually performed simply by executing the wills, and there it stopped and there it finished, and it left enough room for an applicant then to say, well, that's great, but I'm still here to challenge. I still meet the criteria that I need to meet to make the family provision application, and here I go. So what we're going to do is, from Barnes and Barnes, going to move to a more robust version of that. It's fairly close to my heart, given at the time Cleary Hoare were acting for an estate up in the Gulf, a cattle station estate, where we merrily went along the way that Barnes and Barnes had. We'd gone a lot further than Barnes and Barnes, but not far enough. And Barnes and Barnes was decided about a week before our trial. Now, we'll see in a moment what we had done was enough to get us through it, but it certainly got us thinking about how we might make this process and this strategy to impose liabilities on the estate for the benefit of particular people. How do we make that more robust, more easily enforceable, and more visible to third parties, to put them on notice that nothing's happening here in this estate until these liabilities are met? So our option is what we call the Aegis will, Aegis being the shield of the Greek god Zeus, impregnable shield. It's been in this form now for 20-something years, so long as I've been in the practice. It focuses on the ability to, on the one hand, maintain ownership of property the way that the testator wants to, so to not trigger any stamp duty or CGT or any other land tax or rates or any other impost, to leave that as it is, but to take steps to separate the value of those assets from the risk, in this case, the risk of a challenge by a family. Value is using Bloodline Trusts, which are established during the testator's lifetime, so they're a bit like a discretionary trust. We've had earlier presentations on Bloodline Trusts and their use in estate planning, for those who want to have a deeper look at that. So the trusts are created during the lifetime of the testator. Those trusts commit to a form of contract, it's a deed for contractual will with the testator, setting out the deal. That contract is very detailed and enforceable and properly put together. That contract, along with the security that runs with it and is registered over the assets, gives the Bloodline Trust a priority claim over all creditors of the estate, other than any existing secured creditors like banks, who would be number one. So it's about impairing the estate with liabilities that go towards supporting the client's instructions that assets they have in their name must go from their name to person A or B on death, even if there's a challenge. And when I was a younger lawyer, my master then, John Hall, explained it to me that we are just here to enforce the golden rule. I said, John, what do you mean? And he said, well, he who has the gold makes the rules. So if our clients are the ones who have the gold and they're giving us these instructions, our job is not necessarily to counsel them on that as to relationships, but simply to put in place enforceable and robust mechanisms to ensure that their instructions are effective and implemented. So the Aegis will arrangement is a multi-layered arrangement. It's a belt and braces approach to asset protection in the context of estate planning. The first phase is relatively simple in concept. We would say to the clients, to Helen, what do you think your equity and your assets in your own name are, the assets that you want to protect? And she would have identified the equity in the family home and in the unit. That would have a number attached to it, 1 point something. I haven't got the numbers in front of me, but quite a bit of money. We'd say, fine, well, we'll start a new bloodline trust. That bloodline trust will be controlled by you right now and will continue to be controlled by you for as long as you want to. But on your death, the new controllers will be Charles and Caroline. We may even have more than one bloodline trust, but for simplicity, we'll just call it one at the moment. They'll become controllers of the bloodline trust. The corporate trustee of that trust, which will be controlled by Helen during her lifetime as well, will implement this transaction. So we would have Helen make a gift, and we'd document that gift of money from Helen to the trust. Trust would loan the money back to her under a written loan agreement, interest-free, repayable on demand. And for the tax accountants among you, there's no need to worry about Division 7A here. There are no corporate beneficiaries. So a relatively simple loan agreement, repayable on demand, but where the bloodline trust can call for security, and that security could be in the form of a mortgage over real estate or a security interest under the PPSR. Once we do that, what we've really done is convert a whole heap of equity in Helen's name to a liability. The equity is moved to the bloodline trust, and really the bloodline trust is acting as a family bank in the context of asset protection to make sure that there will be no other claims that will get in front of it other than existing mortgages to banks and so on. We then move on to another phase in the Aegis will process, and that is to draft and explain and ultimately execute a contract between Helen and the bloodline trust that documents the deal between them, that I promise that I'm going to make a gift of these assets. That goes much further than Barnes and Barnes. Barnes and Barnes just said, I promise that I'm going to do a will in a certain form, and that's it. So Helen would promise that she's going to make a gift of particular assets to that trust. There will also be provisions in the will contract which create enforceable rights for the bloodline trust, and those rights are measurable in money terms. The bloodline trust becomes a creditor during her lifetime, not just after her death, and it gives us a much clearer path to enforceability in the event that the bloodline trust wants to press its claim if the will is challenged or other trigger events occur. And the third layer in the Aegis will strategy is an option agreement, and this was what we used in the proceedings we were involved with when Barnes and Barnes came out. We didn't have mortgages, and we didn't have, we had a deed for contractual will, and it was quite good and it worked. But our last line of defence was an option. The bloodline trust had an option to purchase the property to which it was entitled under the deed for contractual will. That option was exercisable at that time for $1. Our present approach is to exercise the option for market value less the amount of money owed by Helen under our secured debt process. So one way or another, have the option exercised for quite a low amount or nominal amount of money. And that would be the last line of defence, because it is a dutiable transaction. The exercise and transfer of assets under that option would be subject to stamp duty that the trustee of the bloodline trust would have to pay. And it would be a CGT event for the estate. That would sometimes cause some problems for the estate, usually big ones. It's a very compelling position to be in when you're at that stage in a dispute. But so far as outsiders are concerned, anyone who on our advice takes this approach would have visible to third parties fairly quickly during their lifetime mortgages to the bloodline trust. PPSR security interests are searchable, they're visible. The third parties don't get to see what's behind it. All they see is that there's registered security that would send them a message very quickly that the bloodline trust stands in front of any other claimant in a family provision application. If though we're just looking at the enforcement provisions in the contract, if we ever had to look at that, there are a whole range of enforcement triggers, things like perhaps Helen changing her mind, through loses capacity or remarries or whatever, tries to change her will to something else. It's okay if she controls the Bloodline Trust as well, but if for some reason she handed over control of that as part of her incapacity, then the Bloodline Trust could enforce its rights under the option agreement, under the mortgages and so on, to secure those assets. If Helen was sued by someone during her lifetime, the contract would be enforced and the assets taken. Or that last blue dot point there, if the assets fail to pass under the will within the bequest period, so we've talked about that date of death plus 6 months, we might say, well, look, if the asset fails to pass to the Bloodline Trust under the administration of the estate in the first 12 months, that's enough. That's a breach, and the Bloodline Trust can take measures in the Supreme Court to enforce its rights under the contract, under the mortgages and so on. And failing all of that, it certainly gives rights to the Bloodline Trust to issue proceedings for liquidated damages, being the net market value of the assets it's relying on receiving. So the Aegis will package or process is a belt and braces approach. It has a number of layers, starting from the relatively simple, I guess, approach of the gift and loan back beginning there, moving into the will contract and ultimately to the option agreements. Gives a variety of triggers and defences which can be used to any claim against the deceased estate, either during Helen's lifetime, if she was sued personally, or in this example, after she passed away. So the Bloodline Trust will receive and enjoy the benefit of priority rights over the estate. Its security gives notice to third parties about that priority, and doesn't trigger any taxing events unless the option agreements are exercised, which hasn't happened yet. So other than that, there are no taxing events, no stamp duty events, no change to land tax, no change to rates or anything else. But all it does is create very comprehensive liabilities and enforceable liabilities over personally held assets, which will stand in front of any claim by a challenger. So looking a little bit deeper before we move on to superannuation, well, it's all very well to look at the Bloodline Trust as an inanimate object, but when Helen dies, who would control it? On the basis of what we understand of her intentions in her estate, it would be Caroline and Charles who would become the successor principals and appointors of the trust. So they would be the ones who would be making decisions about, well, do we enforce our rights as controls of this trust or not? They may change trustees, they may appoint themselves as trustees. That'll be up to them, but those rights will be enforceable one way or another, either by simply calling up the monies owed to the trust under the secured debt process, or maybe, if necessary, going further and enforcing the provisions of the deed for contractual will. And in order of priority, and in our experience in practice, this is the sort of steps we take. If we wanted to send a message, we'd make noises again to the executor that we're going to call up the loan if we're acting for the Bloodline Trust. If we're not, we might sue the executors for damages on the basis that, in Helen's example, Rick's made a claim. We're concerned about that being a breach of the deed for contractual wills. Failing that, we could even simply exercise the option if we're acting for the Bloodline Trust in those scenarios. On any approach, the estate would be left with no assets within or upon which any family provision order could be made. Rick would probably still have had the life interest and the life tenancy in the unit, but that was what Helen had intended in any event. So we'll move on to the superannuation side of things and look at, again, just recap quickly on what the family group looks like. Significantly in the superannuation world, in this family group, Helen and Caroline were together trustees of the super fund, although Helen was the only member. Remembering Helen didn't get on particularly well, as it turns out, with Rick. The assets in the fund was an entitlement of $450,000. What that was made up of, we don't know, but that was Helen's monetary entitlement, her accumulation account. Helen, unfortunately, didn't leave a binding death benefit nomination. Those of you who work in this area a lot would realise that the self-managed superannuation fund, you don't need to have a nomination at all. You can have one that's binding, non-binding. You can have one that's lapsing, non-lapsing. There's a whole range of options. But whatever the option is, it must be reflected in the rules of the super fund. So start there, see what the rules are, see what your client's objectives are, and use binding death benefit nominations or lease nominations accordingly. In this example, the rules of the fund put Helen in a position where her binding death benefit nomination had lapsed. It was more than 3 years old, and in any event, she'd nominated her grandchildren as beneficiaries of her superannuation funds, which of course those grandchildren don't fit within the definition of dependents for SIS purposes, so it probably would have failed anyway. But it seemed fairly clear that she'd intended that the super monies, one way or another, go to the grandchildren equally. Perhaps a better way of doing that may have been to have a nomination for the funds to go into the estate and then deal with it in there. So the trustees' actions, remembering the trustee, initially trustees were Helen and Caroline. Helen passes away. Caroline's a sole trustee. For whatever reason, and maybe it was on advice or certainly an element of the dispute, Caroline appointed her husband, Martin, as a co-trustee of the fund, and then they together made a decision that they were going to distribute all the superannuation funds to Caroline. There are a lot of irregularities in the documents, but that was the process that Martin and Caroline sought to implement. Now, we also know that self-managed superannuation funds are not subject to the jurisdiction of the Superannuation Complaints Tribunal, and so really the main arena for disputes in this area is in trust law, which means we're in the Supreme Court in each state. And the Supreme Court's jurisdiction in this area and its ability to make orders is not about whether X dollars was paid to Caroline, whether that was right or wrong. It's simply about the duties of trustees. Those duties are fiduciary duties. Their duties are trust law, and their duties to act in the interests of all beneficiaries, not just one or not just some. So the court found that the trustees, the personal trustees, Martin and Caroline, had breached their fiduciary duties. Bearing in mind they are personally liable for those breaches, whatever the damages may ultimately be. The court found that the decision by the trustees was in breach of trust. They replaced the trustees with a new trustee, and it's possible that in some circumstances you have an independent trustee appointed here, but that's where the jurisdiction of the court runs out on this sort of application. So it says, well, there's been a breach. It's not for us to fix the breach right now, but we will appoint new trustees, and someone can come back to us on whether they're going to sue the old trustees for breach of trust and breach of fiduciary duty. So everything is wound back, money's put back in the bank account, new trustees appointed, and they start again. And that's not a very cost-effective process, as you'd appreciate. So if you're thinking about these sort of things and some of your clients, and what do you do in similar circumstances when one of your clients, like Helen's, passed away, grab the trustee, look at whether the rules of the trustee to line up with what's actually happened on the ground, about death benefit nominations, about passing funds to the estate or whatever it's going to be. Suggest to your clients they need to get advice about their fiduciary duties and about the terms of the trust and whether what they've got is enforceable or whether there's some risk to it. And then they can determine, based on that advice, what decisions they make. Were the trustees to seek independent advice on those matters, some of the advice may have been, what we've seen in the case note, may have been to appoint Charles as a co-trustee rather than Caroline's husband, Martin. That would have been less offensive, I would have thought. They should have documented some of their deliberations on and made sure that they were seen to properly consider the needs of all beneficiaries who may receive a benefit from a self-managed super fund. They should look at the intentions of the deceased member. Whether those intentions can be achieved is another matter, but they should at least look at them, and from there look at the options. Maybe some of the options would have been to split the entitlement between Charles and Caroline as children of Helen, or maybe between Rick and Caroline and Charles. Maybe put it into the estate and then take it from there. But of course, none of that happened. If you're looking from a planning perspective, what can be done before someone passes away? Update the estate plan. I'm not sure that the estate plan is actually often a single document, but there's obviously touch points that we've talked about today: wills, superannuations. We haven't talked about enduring powers of attorney or other things like that, but there are components of that. For the purpose of this part of the paper, a binding death benefit nomination is certainly worth looking at to determine whether it should be binding, whether there should be a nomination at all, and where the death benefit should ultimately go. And once that's all clear, make sure the fund deed lines up with the documentation and the client's wishes. And if it's to be a non-lapsing nomination, then make it so. Of course, that's difficult to do, almost impossible to do with retail funds. You have to just accept that 3-year lapsing period, and almost all of you will have untold checklists on that aspect of your financial advice in any event, so very unlikely that that would be overlooked in practice these days. You think it can't happen to you? Well, we've seen 2 separate Supreme Court actions in Victoria with the Marcella family. There are other cases which we presented in earlier papers, and for those who are interested, we can send you more detail on those, of Munro and Mandy's case on similar bases. But overall, the conclusion is that estate planning is something which is an ongoing process. It's not necessarily every year, but there are events which occur in clients' lives which prompt a review: a death, a divorce, some form of disability, a retirement, purchase or a sale of a significant asset, and so on, are all things which are a flag to look at the estate plan and where all this might end up when someone dies. Don't ignore the risk of a family provision claim. It's not in every family, but if it's there, if you can see the signs, then raise the risk with the client, make them aware of the risk, and ask them if they'd like to look at a solution. If that's all you've done, that's a good start. If they want to do something about it, then we've looked at least one way of dealing with it comprehensively here, if it needs to be done. Whatever the cost of that advice is, and your time and effort in dealing with it, is probably going to pale into insignificance compared to the costs of running actions in the estate after they've gone. And most unsettling for your client will be they won't be around to see how it all pans out, or to see whether their wishes are in fact implemented and enforced. Any questions?